start this and then turn it over to committee chair Duncan Patterson. Duncan.
Thank you, Ed. Ed said I'm chairman of the Drug Testing Standard and Practice Committee. I'm currently chairman of the Delaware Thoroughbred Racing Commission. As Ed said, the purpose of this meeting is to enlighten us on the new medication rules and the Drug Free Sport International, who is going to be administering these rules. Ed, whom do we have from representing either the authority or the drug-free sport medication?
We have two of the anti-doping committee members, Dr. Scott Stanley and Dr. Mary Scalay.
Oh, great.
And we have Jim Gates, who is on the HISA staff, who is the staff member for that committee. And I think I saw Hank Zetland come in, who I'm not quite sure, Hank, what your current title is, but he's also affiliated with HISA and has worked on with this committee over the past several months. We did invite the chairman of the committee. We've never gotten a response, either declining or agreeing to any of our invitations from the chairman of the committee. And I don't really know how much interaction he has had with any state regulator or executive director in this space. So with that, I don't know, Jim, how do you want to handle this? You want to go directly to Scott or Mary, or what do you want to do?
No, thanks, Ed. I'll kick it off. We just have a really brief intro of a minute or so, and then we really wanted to maximize the amount of time that you all had to ask questions. So just to let you know, or to refresh everyone's memory, or let you know if you don't already know how we got to where we are. Our committee, the Anti-Doping and Medication Control Committee, started doing its work in earnest back last summer in July. And we worked with, as required, we negotiated with USADA, the United States Anti-Doping Agency. We put together a draft protocol and other documents at the same time as another group on behalf of HISA was negotiating on a management services agreement with USADA. For several reasons, we were not able to enter an agreement with USADA. We didn't think that that was necessarily the right direction to go. And so then we pivoted to a negotiation with the Center for Drug-Free Sports, or DFS. And once we came to an agreement with them, we took another fresh look at the protocol and the surrounding documents, the ancillary documents. Going back in time again, but to last fall, we put out draft documents for the industry to review and provide feedback. We got that feedback. We used that in our negotiations with USADA, made changes to those documents. But once we pivoted to working with DFS, it changed basically who had the pen in these documents. It gave, whereas USADA was writing and we were negotiating in the past, it changed to us actually having the pen. And so we've made some fairly significant changes that, based on the feedback we're getting, have been pretty well received in the industry. But we've made some fairly significant changes to the documents, especially the protocol. And you may have seen, if you've looked at the documents, we've now changed some of the terminology from primary and secondary substances and methods to banned substances and controlled medications. And we actually have split the protocol into two sections so that you can see what we think is the very important differentiation or distinction between those two, whereas it appeared that everything was being treated as a banned substance, or at least to the somewhat untrained eye, it certainly was confusing and looked like all of these, even the therapeutic medication overages that were unintentional were being viewed as banned substances. So we've changed that. We changed the B sample laboratory testing so that the person who has been charged has the option to have the B sample analyzed at a different lab. And then we made some fairly significant changes to the sanctions section to differentiate between the sanctions for banned substances and those for controlled medications. So we put these new documents out for public comment on June 2nd. We've gotten several of our constituent groups have sent in, and actually more than several have sent in comments, and we're in the process of considering those comments. They're all very helpful and thoughtful comments. And so we are, our committee is getting together and considering what changes we want to make. And so to that end, we appreciate the opportunity to speak with this group, because I'm sure we'll get some good comments from you all as well. And we're happy to answer any questions that you have. Mary or Scott, do you have anything you want to add to that, or Hank?
No, I think that's a great point to start. Just do our best to answer the questions from the different representatives.
If anybody wants to be recognized, just raise your hand and we'll go from there. Duncan, you would go first.
Okay, thank you. I have a couple questions. My concern is, and Scott and Mary can certainly answer this, that the therapeutic medication with threshold levels and withdrawal times, administration times, have been developed over years of research, modifications, testing on sample horses. And I cannot understand why we did not keep those existing rules. In my perception is the real problem was the application and enforcement, the lack of uniformity of application and enforcement, whereas the rules themselves were not broken. So Scott, Mary, I'd like to hear your comments on why we are changing somewhat drastically, not as drastically as the USADA provisions, but to me, this is changing it fairly dramatically.
I can start, and then probably Mary and Hank might step in. But one of the first things, Duncan, that we had to deal with is this is federal law. It's written into the code that requires that the effort work towards and every effort be made to get to the IFHA standard, which is an international standard. So many, if not the majority of the restrictions that were pushed forward are because the IFHA standard required it. And that's actually written into the law. So we didn't have a lot of leeway to make decisions that would allow us to be less restrictive than those. So that's a baseline point that we had to start with. In many cases, we did utilize information where IFHA was silent to address those areas. And we did address many other areas and had multiple discussions about how that would fit into the racing in the US. So many of the things that don't line up are because of requirements, like an FDA, that drug is not approved by the FDA, or in circumstances where we had an FDA approved drug that they did not address. So most of those guidelines are based on the fact that we had a law restriction to IFHA requirements.
Thank you, Scott. Isn't it true, though, that we adopted many of those FHA, IFHA restrictions when we structured our policies?
In some cases we did, but in many cases we did not. And so because of the law, we needed to go back and address each one specifically and what IFHA said. So oftentimes that was our starting point. This is what the current threshold and withdrawal guideline is. This is the IFHA rule. So they were all directly compared across. And anytime there was a concession, it was because there was a very specific reason for that. For example, the best example I have, it's not approved by the FDA.
Thank you. Mary, do you have some comments?
Well, I guess the other thing that I'd say is that the IFHA substantially regulates substances through urine testing, whereas with the controlled therapeutic medications, we have focused on detecting substances in blood. So a fair bit of effort was put into looking at available research to see if the thresholds that how the thresholds that we used in blood aligned with the urine screening limits that the IFHA uses. And I would say that by and large, there are not many sea changes in how the medications are being regulated. It's largely a difference in the matrix being tested. But Scott, you can speak up if you disagree, but I think as we went through the list, I mean, some of them are exactly the same.
Yeah, just to agree with Mary, that was a bit of a challenge. How if they had a urine rule, we had a plasma rule. How we make those things as similar as we could.
We have a question from Dr. Cole in Florida.
Yeah, so just to be clear, because I haven't had a chance to look through, so by and large, we're now moving everything back to urine testing, or as much as we can, but by these requirements.
No, that's not what we meant. I apologize if I was unclear. Where we had a plasma rule and they had a urine rule, we tried to accommodate our plasma rule with comparable withdrawal guideline and threshold that was equivalent to their urine threshold.
Okay, thank you.
Any other questions? If not, I have one. I guess is for Mr. Gates. One of the real problems that we have, and it's certain that both Mary and Scott would agree with this, is the need for research to identify those medications, or in this case, probably drugs, that we don't have tests for, and develop those tests. Classic example is the South American frog juice, where we knew it was being used, which had a very strong painkiller, 40 times more, I might be exaggerating, than morphine. And we banned it, although we banned it in July, but we didn't have a test for it until the following April. And as everybody knows, it's very difficult and time consuming to develop these tests. So the financial resources that we don't really have to identify those drugs is a real problem. How does the authority tend to address that situation?
It's a good question, and yeah, we're certainly, our committee has talked about it, and we're certainly aware of issues such as that. Mary, do you have I mean, we've got a DFS will likely be working with us closely on that. Mary, do you want to give your 2 cents on this one?
Well, that's probably all it's worth, is 2 cents, because I think it's a work in progress.
Right.
I think DFS and the authority are still trying to understand what the potential relationship might be with the RMTC and what the RMTC's role might be going forward. It may be almost exclusively related to research initiatives because HISA or DFS will be taking over oversight of the lab accreditation. They'll have an educational component. And so that it could be that the RMTC gets to continue to function solely as a research directing and funding organization. But I think early days yet, I'm not sure how it's going to play out.
Jim, can I add just a little bit on that?
Yeah.
One of the things that that was a continued discussion through this is, establishing better uniformity between the laboratories. And so an underlying, effort will be to make sure that all the laboratories are, doing the same, level of work, comparable work, and, a better dissemination of the available information. Duncan, as you know, and I'm sure many of you understand that, there's always been, somewhat of a delay and a disconnect between the laboratories, some developing a method, and then, others, trying to validate that and distribute it. The idea would be to streamline that dramatically. You gave him the example of the dermorphin and it taking, almost a year to get that rolled out. And I would say, 3 or 4 months of that was just, trying to get everybody to agree that this validated method was acceptable. And I think that, we'll find ways to cut that down to shorter periods of time. At least that's a discussion I've had many times.
Dr. Cole has a question.
Right, it's maybe a little premature, but since you brought it up, Scott, since we were trying to get uniformity into the laboratories, does the authority plan on addressing disparities in funding for the various laboratories in sort of their contracts? My understanding is next January, I'll be talking and my contract will be with the authority, not with the state of Florida. Any insights into how the authority views that? Because there's obviously, as you well know, a lot of disparity between the fundings for the various labs.
I can't answer that directly with there's a plan. I can tell you that it is, something that is well discussed, and the concept. There's a bit of a problem with exactly how to structure fees and financing and testing costs based on free market. But the concept is that it would be a similar cost for everybody to do the same work, and for a laboratory that's asked to do more work, it would be expected that they would be helped and funding would be provided. Now exactly how that comes and how long it's going to take for all those things to come together, I can't answer that.
I will add, because I've had a couple of conversations with Larry Bowers, who is a member of the Horse Racing Integrity and Welfare Unit, and he has extensive experience in having managed labs and overseen programs, and he fully understands that there are individual labs that may be vulnerable because they have not had adequate support in the past, whether it was for staffing or instrumentation or whatever. And there is absolutely no appetite on anyone's part to have a lab fall by the wayside and be eliminated from the program because they were not able to, have the staffing or the instruments required. So although I don't know how they plan to address it, they're aware of the risk and they plan not to have that risk manifest in the loss of a laboratory.
Appreciate that.
Any other questions? I have one. As I read the document, if there was a positive reporting to the authority of actually stewards or whomever, that the commission who's overseeing that, where that positive took place, is not advised of that positive. And I think that is a real failing. I mean, the commission has to know that there's a positive that might prevent a horse from being entered or a trainer being given days. Why is the local commission kept in, for lack of a better word, the dark regarding a potential positive?
I think that is information that was previously put forward, but not factual any longer. The information and the relationship for testing will be between the agency, which would be Drug Free Sports International, and the laboratory. So they will be the first ones to get that information, but they will be coordinating directly with the commission in order to see that there's a proper investigation, proper people were notified, etc. So Duncan, I think there might be a little bit of, you know, a gap in time, but it is never my understanding that they would be excluded from having that information. They may just not get it directly from the laboratory. They would get it from Drug Free Sports on the notification.
Okay, thank you.
Yeah, I think that language actually came from USADA, and we have had multiple discussions about the impracticality. I mean, the logistics of keeping a commission in the dark, and it's just untenable, you know, whether it's addressing purse distributions or suspensions or notifying horses that ran second in a race that they are now, you know, racing as winners. The committee was quite clear that commissions are not to be uninformed or left out of the loop. So that has been addressed. I'm not sure why the language is still there because we've had multiple conversations. And
Yeah,
it is clearly understood that the commissions have to be included in the information loop.
Well,
Thank you.
Duncan, we'll go back and check that language and just make sure that it's what we intended.
Okay, thank you. We have a question from Virginia Tech. Is that?
Virginia Fields of Texas.
Okay.
Yes, sir.
Excuse me, I'm sorry.
No, that's all right. That's all right. Arkansas, actually, not Texas Tech. But, in your rule 6130 for the laboratory accreditation and to maintain that accreditation under HEAL, it mentions that the labs cannot accept any monies from covered persons, and to avoid potential conflicts of interest, they not maintain relationships with those covered persons and racing commissions. Is that still as proposed on your website, on the website?
So the language, basically the intent of that language is to prevent the covered person from contacting laboratories directly and having their horses tested. We did have discussions and understandings regarding split samples and other, you know, tests that are, you know, are paid for by covered individuals, and it was not the intention of that language to prevent them from, you know, having to pay the laboratory for a split sample analysis. So it was intended so that the laboratory is not directly developing a relationship with a covered individual to test their horses without going through the agency or the authority.
Well, and if I can,
I think there's also an understanding that there needs to be perhaps an individual conversation with each laboratory because they have certain circumstances beyond their control. The land grant universities have in their mission statement service, and it's not clear that they are able to decline to receive samples from outside individuals. And so I think as the contracts are drafted and contemplated, that issue will be addressed specifically and likely on a more local basis rather than just having a global policy that may contravene, you know, a university's mission statement.
but it would be my understanding that the rules would control over a contract. And so in that regard, it's my understanding that you're going to prohibit trainers from exercising best practices and having their horses tested through these laboratories, but they'll have to find some other laboratory in order to double ensure that their horses are participating without a prohibited substance.
No,
That's not correct.
Okay.
Yeah,
Help me.
Virginia, the confusion there is, the agency can't be left out of that arrangement. And currently, the jurisdictions that I've done work for in the past always work the same way. If a trainer contacts his veterinarian, his veterinarian contacts the commission and says the horse was being treated with X and we withdrew that, but we'd like to test it before it competes, or it has to test to come off the vets list. Those things are all coordinated. And while the trainer may in fact pay for that directly, it is through an agreed relationship with contract and an understanding by the authority and the commission, and the agency that work is being done. So it would not be required a third-party laboratory that potentially didn't have the same testing capability.
So we would constitute, at least make a recommendation that it not necessarily be that the covered person not, or that the laboratory not receive a payment from a covered person, but not contact the covered person from the covered person, correct?
Yeah, I mean, I think a better way to say that is, that they don't, go directly through them, because I've had situations because of, time and race dates and everything going on where the covered person directly brings that sample themselves. Now, we have had circumstances because that horse is in a race that came up that was added to the overnight, and circumstances change very rapidly. Their veterinarian contacted the racing commission. The racing commission is fully aware of that circumstance. So I think it's just a matter of, some fine detailing, but there is no intent of excluding the covered person from being able to get a horse tested to make sure that they would be, competing without a potential violation. It's our effort over the long period of time is to make sure that we do everything possible to make sure that a horse not compete if they haven't cleared the medication.
Yes, sir. And I would only say that, we just don't want to run into some sort of, from a commission's standpoint, we wouldn't want to run into some sort of conflict with our laboratories that we've dealt with for years because, they want to maintain a HEAL accreditation. Thank you.
Any other questions? This is more a suggestion than a question. As I read the protocols, if a commission investigator discovers needles or, for example, mislabeled medications or medications that are not FDA approved, that immediately goes above the stewards. I would recommend that you handle this similar to the crop rule, whereby if the stewards determine that a rider has utilized the crop in excess of the given, and the penalties are set forth, and then they issue that penalty, then if an appeal is made, then it goes beyond the commissioner or the stewards. I would recommend that they have certain penalties for the things I just described. And if the person wants to appeal it, what I'm suggesting is I think we want to minimize the bureaucratic process as much as we can and have the stewards do as much of the work as possible, rather than send everything up above to the FTC. Obviously, appeals would be handled as provided, but I would suggest we have many of the penalties adjudicated at the local level. What is your thoughts on that? Jim Gates, I'll put you on.
Yeah, I'm mulling it in my head as you're saying it. I think what you're saying has some validity to it. I'm just trying to think how it fits in with the rest of the protocol. So what we'll do is I'll take that back to our group and we'll give it some consideration.
Another concern I had was, as I read the protocols, if somebody wants to appeal there's no provision. Well, there is a provision for a stay, but it seems like the stay has to be adjudicated above. And I have to confess that the stays can be very frustrating for a commission. We handle all appeals by our commission in Delaware, and having given stays is frustrating. But in certain cases, the stays really are appropriate. So it seems to me that the stay provision in these protocols is very limited. Again, Jim Gates will.
That'll be something that the lawyers will have to weigh in on. So I'm taking notes here, and we'll take that along with your previous question or recommendation about how we handle the issues that have been uncovered by investigators, and whether the stewards are involved in that adjudication.
Thank you. There's got to be more questions that people have. I found this better than the original USADA provisions. It seemed to me that USADA substituted equine, where a human was in their regulations, and it was in many cases not appropriate, not reasonable, not actually practical. So, but it still does not address specifically how the urine samples and the blood samples will be taken at the local level. Is there more to come? I guess Scott, Mary, Jim Gates.
I believe there are supporting documents that address sample collection, labeling, processing, that sort of thing. I guess I would like to take a minute just to put a plug for the DFS folks. For those of you who haven't met them, they have been a breath of fresh air. They've identified themselves as a service provider. They haven't told any of us how dumb we are, and have been methodically, well, it's a plus, have been methodically visiting multiple test barns to see different operations, compare and contrast. They came to Turfway, God love them, in the middle of the winter, and they spent the whole evening in the test barn. Nobody wanted to go to the clubhouse for a drink. And they spent a lot of time with the test barn administrators looking at documentation, asking how they could make things easier and more efficient, how they can eliminate risk of errors in terms of transcription of information. So I came out of that meeting feeling far better than I had in quite some time. And if you get a chance to have them visit your test barn, I think you should. They instill a lot of confidence in their approach to servicing our sport, instead of having our sport fit into their cubby.
Yeah, and I can add, Duncan, just to clarify, because we spent a lot of time talking about this with USADA. They were very specific, USADA was, about the test kits that they wanted, the level of security, the manufacturer, the barcode requirements, etc. And we had to back out of a lot of that because it was, kind of a quite expensive kit that they absolutely would not, consider any other. And we know that jurisdiction to jurisdiction, the states have different utility that they've had depending on the lab, depending on the requirements, their own laws. So we're trying to accommodate the multiple jurisdictions and the fact that one size may not fit all, and get that addressed into those supplemental documents. So it is something that we'll have in hand, or everyone, very soon. And I think it'll be a lot more easily absorbed and understood than previous work.
That's really good news, because my perception was that USADA wanted to have absolute control over everything. So rather than working with us, it was their way or the highway. I mean, I have a great deal of respect for USADA, but it seemed that USADA was somewhat overreaching as far as their authority and control over the medication protocols. Hank Zeitlin, I don't want to put you on the spot, but Ed did not know what your title was. I think it's VIP, isn't it? Very important person. Do you have anything to add?
No, thank you, Duncan. I think it's been a good conversation. One thing, I guess I will add one thing from the perspective of the act and the way it's written. The agency is the one that is responsible to write the rules that are recommended to HISA to go to the FTC in consultation with the committee. So USADA was tasked with writing those rules, consulting with Jim and Mary and Scott and their committee. And when HISA landed with DFS, DFS has that responsibility. It's just been a different dynamic between the agency and the subcommittee. So, and I think you've noticed that through what the draft looks like. And I think HISA has continued to be very responsive to input. So I just encourage everybody on the call to submit your comments through Jim and his committee, because everything I've seen, you guys know I've been around a long time. The committee is taking into account and really considering thoroughly input that they get to try to make the rules as good as possible from the get-go.
Dr. Cole has her hand up.
I'm just wondering if there's any, has been any discussion of them, the agency reaching out and having any discussions with the laboratory directors. At least a couple of weeks ago, I queried and nobody has had any discussions or very, very minimal discussions. And I know everyone's been really busy with a lot of stuff, but obviously there's an awful lot we think we're going to need to do. And it would be great if we could start having some discussions with them, or at least get some input.
Cindy, I'll jump in and tell you that I can, from the get-go, and I think Mary, Hank, and Jim will confirm this, that I've been pushing and pushing for, continuing education, communication. So I think what happened was we had to go back and revamp quite a bit. And as we've done that, we made some changes. So it kind of made sense that we didn't start training off documents that weren't finalized. But now that we have them finalized, and Mary and I have even had that discussion very, very recently, that we do need to outreach and we do need to communicate with everybody out, not just the laboratories, but the jurisdictions as to how best to implement and what needs to be done. I can say with high degree of confidence that none of the labs are going to be blindsided by this. They're all going to be shared as much information as they can, and pathways that we need to go to get that done. It is not an intention to exclude anybody or to do any gotchas or anything like that. We're all kind of in the same boat. Even my laboratory hasn't been able to start any big changes because things haven't been settled. So even
excuse me, Scott, but it's not so much, I just knowing our group, it's not so much that we at least worry about being blindsided so much as feel as though input and discussion maybe would have been a little bit appropriate in terms of it's, I mean, I don't know, it's hard to explain. Certainly this is going to be what it's going to be, but you'll get a lot more and it will go a lot easier, I think, if the laboratory directors feel that they have at least had some discussion before things are finalized. Otherwise, and I don't mean this in how it's going to come out, but this isn't sort of Scott Stanley and the agency sort of developing the protocol that we're all going to follow, if you know what I mean.
No, I do. And I think, in the long run, you'll find out that, some of the people even on the subcommittee have had a lot less input than we would have liked. But, the law kind of defined what we were able to do, and and how we able to do that. But I do hear what you're saying, Cindy, and
Yeah.
I've been pushing for a long time, to be able to, have, communication and outreach. And there's been, some reluctance and indications, well, we'll get to that. But I know we will.
Understood. And as all, the devil is always in the details. So as the implementation is, people are reasonable, and I think allowing some discussion, I don't foresee there to be problems, but
Hey, Kim, there's a
Mr.
question. This is Hank. Dave Basler asked a question in the chat about how long the drafts are going to remain up for public comment. So Dave, they're up there now. They won't be taken down. The authority has to submit them to the FTC, and similar to the racetrack safety, the FTC is also going to have a public comment period. They're meant to put it up after they publish it to the public register. So the submission by the authority to the FTC will be within the month. It'll most likely be the beginning part of next month.
So it'll be up to the end of the month, Hank?
Yeah, I think what you want to make sure to get your comments in this round by the end of the month, but they won't be taken down because you got to get your comments in so they can be wrapped up into the version that gets submitted. But it's not like that's the end of the rules. There's always going to be changes, so the rules will continue to be posted for comment. They just won't be worked into the first version.
I appreciate it. It's I think it's about 340 pages, so it's a little voluminous and takes a little time to get through and make comments on. But I appreciate the answer.
Yeah, no, understood. But nobody likes the timeline.
Duncan,
Yeah.
I just I want to go back to something that Dr. Stanley said earlier, because I think somebody brought up the question about kind of the whole format and the reliance on the IFHA standards, and we pulled up the actual statute, and the statute says, to the extent consistent with this act, consideration should be given to the international anti-doping and medication standards of the IFHA and the principles of veterinary medical ethics of the American Veterinary Medical Association. Certainly there's been consideration given to the IFHA, but what that is that is not a requirement that the IFHA standards be adopted. The other question I have, and I'm not being critical of that, because in some instances there's a lot of formatting difference as to how the IFHA standards are presented as the WADA standards are presented. And what hits me when I read it, and maybe I'm reading this, is the underpinning of the anti-doping program has relied, let's put the rules aside for a minute, but the uniform classification document, for which literally generations of expertise have gone into that document with regard to the classification of different substances. And the penalties were assessed based on the seriousness of the substance that was found. Certainly splitting into two categories, banned substances and controlled medications, is kind of the manifestation of a project that many of us on this call had worked on but never really enacted through the RCI model rules. The difference between doping substances and therapeutic overages. and to handle those differently. And certainly your committee has put an approach out that I think is consistent with a larger desire to get there. But I'm curious as to two issues, and one of them has to do with as I read all this, you're kind of throwing any reference to the uniform classification document out the window. We're going to continue to maintain that document for virtue of our non-US thoroughbred regulators and our standardbred and quarter horse regulators. But I was curious as to why you would throw that completely out the window. And maybe I misread it.
I can answer perhaps a little bit, Ed. The first thing that I'd say is it has not been completely thrown out the window. I spent a scintillating weekend, I guess 2 weeks ago, researching every substance on the uniform classification list, 1,200 plus, every last one. And what I think ultimately we're going to have is something that is a hybrid between the format of the uniform classification of foreign substances and what the FEI has on their website, the database for controlled and banned substances. So the uniform classification of foreign substances has been largely consulted in this process. I suspect that it is because HISA, because the authority does not have custodianship of the uniform classifications list, that there is a will to have their own list that they can manage as they see fit. But at the end of the day, I anticipate that there won't be broad divergence from what's on the uniform classifications. A somewhat modified approach, but not a complete throwing the baby out with the bathwater deal.
Yeah, I'm just trying to understand. Yeah, that's helpful. It's kind of like the RCI members, and I know Mr. Shearer has indicated that the HISA at some point would become a member of the RCI, assuming the board approves that. The RCI board approves that. In which case it would be the same kind of thing, but as the schedule that Kentucky maintained, which was largely the same as uniform classification, slightly different. I think California does that too. Others adopted by reference, and that's certainly that's certainly up to each individual regulatory entity. But that's helpful to understand, Mary. And I only had one other piece of advice for HISA staff, and I think Duncan kind of brought up to it. And I had a preliminary conversation with the DFS people and Lisa Lazarus when DFS was first announced. And we had indicated that we'd be more than happy to set up a meeting with all the regulators, with the DFS people, once they figure out what exactly it is they'd like the state commissions to do. Obviously, we're hearing probably what HISA's hearing, and that's a lot of people concerned about potential costs. And the extent to which you want to rebuild things that are already being done at the state level and paid for at the state level, it's certainly your prerogative to do that. But I guess the question for HISA is you'd have to assess as to whether that's the wisest, most cost-effective move, considering HISA has the ability to kind of determine what constitutes a violation, what the penalties should be, and so forth. And if you want to do that, handle that yourself, that's totally your prerogative. But you are probably looking, depending on how this plays out, I think there's been a more difficult challenge for HISA in reaching state agreements on the implementation of the racetrack safety rules, and you're kind of getting there. But it's been quite a, my opinion, it's been harder for you than it needed to be. And that had a lot to do with certain decisions that HISA had made, which were totally your decisions. The only thing I would say is, you know, this big piece, the anti-doping piece, which is really going to fuel the costs and the dollars, of which there's been a significant increase at the state level, and whether or not the states maintain those investments or not. Those are decisions that are going to be worked out, but and in some cases, a lot of states, these issues have kicked up above the racing commission. I know, Hank, this is not something that we haven't discussed, and Jim, I think we mentioned this at some point. So I would just, you know, the more, whether it be an investigation or an adjudication, or the use of a steward, or the use of a hearing officer or a prosecuting attorney, obviously HISA and the enforcement agency will drive and manage that. And perhaps there'll be a lot of states that will cut those employees loose, and HISA may or may not have them as potential applicants to be considered to be hired. But there is a certain degree of expertise out there, whether it be in the test barn, whether it be in the counsel's office, whether it be in the adjudication side of it. And certainly HISA and the enforcement agency can pick and choose for the cream of the crop as to who to use and who not to use. But I do know that it's very rare for a state to get overturned on a drug prosecution, whether it be at the commission level or in the courts. So, you know, the extent you totally rebuild what's already in existence is allowed under the statute, but using what's already in existence is not prohibited under the statute. So you've got a tremendous amount of latitude here. And as the management of HISA and the program people on the committee figure out how to make this all work and not to economically burden an industry that's already struggling, especially in these times of inflation, more than it needs to be to make this work. I just very seriously urge you to consider that. And to the extent that I'm going to speak for everybody on this call, anybody can be helpful to you in trying to think those things through, we'll be more than happy to try to do that.
Yeah, Ed, point well taken. I'll take this back to Lisa and we'll talk about it. But yeah, there's certainly some expertise and some boots on the ground that could be well utilized. So we'll certainly give that we'll kick that around internally.
Yes, Hank and I discussed this months ago, that the last thing I perceived that the HISA management wanted to be responsible for is, for example, the piss catchers. I mean, you should keep that at the local level, and that would again minimize the cost and the responsibilities that the HISA management would have. So just parroting basically what Ed said, I think it's really important that you give strong consideration to keep that those responsibilities at the local level.
Yeah, and I think, Duncan, to that point, I mean, I've stayed quiet because ICE has been very consistent in saying we hope that those systems stay in place and that it's collaborative. Nobody wants to reinvent the wheel that works, and there's many things that do work.
Yeah,
The only thing I would add to that, Duncan, and you've been part of these conversations, is probably as much as I have, and you've heard what different people have said. There is the value of the part of the state infrastructure, and it's going to differ from state to state between investigators and prosecutors and hearing officers and so forth. There's obviously going to be agreements between the enforcement agency and the individual states, but it's also possible that an individual state, if the individual state may choose to not keep, if you're talking about dismantling significant parts of your operation, and I think most states are anticipating that as a possibility, and they're kind of okay with it. The concept of continuing just the collection of the urine samples and so forth, it's almost like and the point that's been made, it actually was made in the strategic plan of the Texas Racing Commission. I know we've alluded to it. The states will run programs consistent with the way federal agencies want them run. There's usually some sort of carrot and stick, not a stick, but a carrot approach, an incentive. But that would maintain that, you know, the states keep their operation in place and then do it consistent with the way the federal government wants to do it. But they don't dismantle pieces of it and just keep the one part that the federal government doesn't want to do. So I don't know the extent to which state commissions may say, if you want us to continue to collect samples for you and contract with a lab, well, we're going to want to investigate and we're going to want to prosecute these cases for you as well. And I don't know. I think that's something that HISA would have to anticipate would come up in some of these discussions. How it all plays out, I don't know. And then, you know, we've had some member states say, well, what's in it for the state to do any of this, and view it as a wonderful opportunity to just privatize this function. So, you know, it's a lot more complicated than who actually runs the test barn and collects the urine and blood samples. So that's the point I tried to make to Lisa and the DFS and make it here for the representatives of the committee. Is my best advice to you is stay flexible on those kind of issues, because you can put this together, but just be careful that the rules that you promulgate and put on the books are not so that they limit your options as you get into the logistics for how to make this work. And I think on the racetrack safety side, I think you ran into a little of that, and that's what complicated the concept of some of these voluntary agreements that you've been working hard to try to get out of the states. But I just say it to try to give you something to think about. I don't have a horse in this race, other than I just don't want this to be harder than it needs to be for anybody.
Yeah.
Yeah, that's duly noted. We've got, I know Scott's got a hard stop at 3 o'clock, and we've got others that on our side that have to run. So we're going to continue to be open for comments. If anyone has any further questions, they can reach out to any of us. But meanwhile, please get your comments in. We're actively reviewing and taking into account all comments.
We'll send you a link to this tape too. I mean, some people may view this as an opportunity to provide some input as opposed to written input. I know you want written input because it helps you do your presentation to the FTC, but I think we're most interested in trying to give you workable input and discussions that may be helpful to you as you finalize these rules.
Yeah, link would be great. I've taken notes, but a link would certainly be appreciated.
Yeah, be easier for you, Jim.
Yeah, no doubt.
Duncan, I don't think anybody else is asking to be recognized, so.
No, there was a question on the chat, but I didn't pick up who it was from, so that it had to do with a cooperative agreement with their lab. So I'm not sure, other than that, what the question was.
That's probably kind of a premature discussion at this point in time, so.
Okay.
Well, thank you all for being here.
Yeah, Mary,